Okay, beaucoup de réaliser les lois, les noms de pouvoir, mal. I would like to write an appeal against that decision.
Thank you. Ms. Kruger, how long is an appeal of this nature then going to be?
My lady, yes. If we get all the documentation, I presume I will be able to submit to our national office this week still, and then we should then be able to get, usually they sit, I think it's the first Wednesday of the month, my lady. So we should be able to get a result pretty fast, my lady. So if I can just get the necessary documentation from Mr. Sekuleni, but I will speak to him now after the court appearance, my lady, to make sure that I submit our appeal already, or recommendation rather, by the end of this week, my lady.
So the time frame we are looking at is how many weeks?
Lady, let me just check. We should have a result in the first week of July, my lady. But yes.
And thereafter consultations must still be finalized.
Yes, my lady. Yes.
And what I gather from this case, it's extensive.
Yes, my lady.
Will that be done before the 21st of July? Is that possible?
I think so, my lady. I'm not, yes. Let me not say a definitely yes, my lady, but
I will have to have a definite something. Either you will not be able to do that, or you will be able to do that. Why I'm asking this is, you can look at this court. There are so many role players that are affected. The administration of justice is affected. So I can't go on a maybe. We must either start on the 21st of July, or we must make alternative arrangements.
my lady, we will be able,
The document more than 5,000 pages. That is not the footage and the tracking.
Sorry, where did that come from? The 5,000 pages? Who's from you? Yeah, but who's so impressed with that? In the gallery. Somebody in the gallery is very impressed with that. Thank you. Thank you. 5,000 pages to be prepared, to be consulted on.
my lady, if we can get the documents already by this week, which I will press upon Mr. Sekuleni, the importance thereof once again. My lady, I think we will be able to proceed on the 21st of July, my lady.
Think. No, definite undertaking. Apologies for putting you on the spot, but I can't work with this uncertainty, because also the extra added issue is that I and everybody will be taken out of circulation for at least a term, and whilst I could have attended to other cases,
No, I understand.
we are struggling with a shortage of judges. Our roles are very, very high, so we cannot afford that.
No, I understand that, my lady. My lady, all that I can say is that from our side, we will definitely endeavour to finalise the processes as soon as possible, my lady. We can even, if it need be, we can ask for the committee to adjourn or convene rather earlier, my lady. So we from our side we will be able to be ready, my lady. Yes.
Thank you. Thank you for your commitment.
Thank you, my lady.
Apologies, Ms. Kruger. Then you have the attitude.
True. What will happen if his appeal is denied?
My lady, based on the information that we have, I don't think that will happen, my lady.
Thank you.
Thank you, my lady.
Thank you, Mr. Sekeleni. Any questions from your side? Anything that the court can assist you with that you do not have clarity on by now? Thank you, Mr. Sekeleni. You may be seated. Mr. Mutlaung, your name was mentioned as a potential legal representative, but what is your stance on that? Are you willing to take a mandate in case of a crisis?
In case of, thank you, my lady. In case of crisis, I am, my lady.
And then you are also confronted with a maybe conflict of interest.
There is no potential conflict of interest.
Interest there will not be.
Yes.
Good. So you can sort of be a standby for the legal aid board. Will that be possible?
That's possible, my lady.
And yes. So Ms. Kruger, you and Mr. Mutlaung will then liaise
Yes, my lady.
on this if there is an issue.
Thank you, my lady.
Thank you. Thank you. This brings me to accused number 6. The matter was withdrawn. The case was withdrawn against accused number 5. Accused number 6, Mr. Theo Franz Mahotsa. Mr. Mahotsa. Your legal representative seems to be Mr. Reineke from Legal Aid South Africa. Are you satisfied that he was appointed as your legal representative and that he will be representing you for the duration of the trial?
I confirm that position to be correct.
And you so satisfied? Thank you for that, Mr. Mahotsa. You may be seated, Mr. Reineke.
Thank you, my lady. As I've indicated before, I'm appearing for accused numbers 2, 3 and 6.
Yes.
And your ladyship raised the question with Ms. Kruger about the preparation part of accused number 4. I have spent 3 days, full days with Ms. Bester, just to make sure that I have the full docket. I can honestly place on record that if someone is taking instructions only now, with the limited time left, if that person is ready, it would be barely so. I've seen the dockets. I've unfortunately last worked on the docket end of February, beginning of March, when my mandate was terminated. So I haven't worked on it again. To look at the 21st of July, next week I'm with your lady. I'm currently busy in Welkom with your sister Boonzaya. Next week I'm with your ladyship with the partly matter in Harry Smith. The week thereafter I'm in Johannesburg for a seminar, and the week thereafter I'm not available. That leaves me only a week left to prepare, and there's no way that I will be ready. I understand amongst some of my colleagues that there might be other issues that would indicate But I thought it prudent to inform your ladyship now already that I do not believe that on the 21st of July this matter would be able to kick off, my lady.
Thank you for the clarity,
Thank
Mr. Reyneke. I appreciate
Thank
it.
you, ma'am.
Thank you. Thank you. That brings me to accused number 7, Mr. Thabo Bester, who is appearing on his behalf.
Mr. Moela, my lady.
Thank you, Mr. Moela. You ready and prepared to proceed?
No, my lady, that is known since the inception when we entered the proceedings in July last year. Yes.
When did you receive instructions?
In July
last year.
Yes, 2024.
Yes.
Yes. If I may address your ladyship in terms of what has caused our delay, in short, is that, or what has caused the delay in the arrangements, is that there is an interlocutory application that is pending dealing with the section 35 of accused number 7, who is the applicant in those proceedings. What he is essentially seeking is that he receive conducive consultation regime, in the sense that there are video footages in a USB that need to be viewed in that particular consultation. In one of the prayers, or what he's seeking, is that he be granted access, his legal representatives be granted access to, or be allowed to have access to their device in that consultation, and he also be allowed to have such for that purpose, and other conducive environment as well, in that we consult in a booth wherein we are separated by a glass window. We consult telephonically, so it might have an impact on his privacy. So that's what is also addressing in that application. So the status of that application is that it's still pending. So it was done in 2 parts, obviously flowing from the directive from the court. Firstly, it was before the court in July, and it was then sent to the civil court to decide whether the nature of the complaint in that application are either civil or criminal in nature, and not to deal with the substantive merit. And we appeared on the 28th of November before DJP. Mbele, yes, my lady. And the matter was reserved, and the judgment was handed down. I'm just looking at my notes.
I think it's January.
21 Feb. In Jan, when we appeared, it was not handed down as yet, my lady. So that was handed down, and the accused number 7 then appealed simultaneously directly to the Constitutional Court, and with the conditional leave before the DJP. So the Constitutional Court handed down its order and refused direct access. So that appeal is pending before Justice Mbele. And we've been given a provisional, not a provisional date, but we've been given the availability of the 21st of July to come. But we said we'll wait for the outcome of today, whether to confirm whether we can be able to argue that. So once that is decided, my lady, whether this is civil or whether the complaints are civil or criminal in nature, a determination will be made as to which forum will hear the substantive merit. And what the substantive merit ahead, we can then speak about the readiness of this matter.
So you were given a provisional date by the Office of Acting Judge President Mbele for an application for leave to appeal on that issue on the 21st of July.
Yes, Mbele. Yeah, that is in a nutshell in terms of where we find ourselves.
Good. So, but you have been properly instructed, and you undertake the mandate for the duration of the trial should the matter commence.
Not on the 21st of July, my lady, because if I was to interpret the question posed by a lady.
But I hear what you're saying.
Yes.
You will not be ready and prepared because you couldn't have concluded the consultation due to the issues raised in the Mbele judgment.
Yes, in the main application. The Mbele judgment, obviously it's one
Yes,
and
yes.
the same thing. But ultimately, is the substantive merit of what is still pending that is going to resolve whether the applicant will be afforded that of which he's seeking. So we have not been able to consult substantively. Obviously, you can do certain consultations that are not going to the merits of the case, because when you deal with the substantive merit, you need privacy to be sort of like assured.
Thank you.
Yes.
Thank you for that, Ms. Muela.
As the court.
Thank you. Mr. Bester, you are satisfied with the legal representation of your counsel, and you confirm what he has just indicated to the court.
Yes, sir.
Thank you. Thank you. You may be seated. Then we go to accused number 8. Yes, you're welcome.
My lady, in July when we appeared in court and when Mr. Moyena came on board, it was an application that was filed, and the Judge President, who was the presiding judge, said it was not documented. And according to me, because we made use of the private counsel, nothing was done yet. In the end, it was the respondent who set the matter down. And that is when the matter was heard, I think, on the 28th. So that is a delay that I am of the opinion that was caused by accused number 7's legal representatives. Then further, my lady, there's a huge difference. The footage is not the alpha and the omega. There are really 5,000 pages that they can proceed with before they come to the footage. But there's a difference if they had consultations about the merits as from the 13th of January, or if they didn't even try to do that. And I would like to know that, did they have consultations regarding the merits in this matter as from the 13th?
Yes, but have you read the judgment of my assistant Bele? Good. So in that judgment, the whole issue is about his access to a laptop and I think 7 hours of consultation. So there are many issues about the consultation that has to be resolved first, as I understand the judgment, before there can be proper and effective consultations. That according to his case. So I don't know if Mr. Mohela wants to answer those questions, sir. Let me just hear from him.
Well, if I may, it's difficult to have a 7-hour consultation in you can't concentrate.
Well, that's what you say.
Yeah.
But you don't know what Mr. Bester's capabilities and Mr. Mohela's capabilities is, yes.
But if you make use of the time, say for instance 2 hours a day, you could at least start in the consultation. And I think that's essential. We must know, did they at least start with the consultation?
Are you willing to answer that, sir? Sorry, Ms. Bester.
Because, sorry, Ms. Moya, I asked before to research if there was indeed consultation, because I must inform the court about it. And according to that, Mr. Moya, as from January up until Friday, he visited Mr. Bester on 2 occasions. And Mrs. Lee on 6 occasions. So, it appears to me that there was not even an effort to start with.
Thank you. Thank you for that. Mr. Mohela?
I about this, Madam. I want to answer that. I have 2 answers to that. Firstly, that's premature to be engaging in this debate because it's something that is going to be what the state is posing for arguing something that they need to argue in that particular application, because that's exactly their answer to their application. So the court needs to make a determination. As I've indicated, the issue is not only about the video footage, but there are other ancillary issues as well, including the number of hours that the accused had requested, including the environment itself, in-person consultation as opposed to telephonic consultation, and other issues as well that in this view would reasonable apprehension that it will affect his fair trial rights. There's certain treatment that is complaining about. It is not the main, but it's ancillary to that application. Because those are the things that need to be dealt in that particular application. In respect of consultation, I've said to you already that we have indeed consulted, but not in terms of the substantive merit of this case. That application itself was a product of consultation, and other applications as well was a product of consultation. Some of the consultation, when given an opportunity, we are able to conduct them here in court if we finish them. But that is not enough to be ready for the trial.
Mr. Mueller, I know that the litigation is pending on the issue, but I, for one, do not see any obstacle why consultations, interim consultations cannot occur. And then after the issue of the pending litigation has been resolved, so that you are ready and prepared to proceed. So just be vigilant of that you do not sit on your hands and then when judgment in what direction or whatever it's going to follow, that you are going to be caught off guard. There's no reason why you can't go to the prison consult in the meantime. But I hear what you're saying, but just be vigilant that this is not a cause for an unreasonable delay. You as an officer of the court must be committed to the expedition of this trial. Good. So you've heard, I explained section 3428 to Mr. Zekaleni, and if you want to, I can explain that again to Mr. Bester. Not taking away his right in terms of section 34 of the Constitution to appeal the judgment of my sister. Good.
Yes, I just want to confirm, I am committed to the expedited hearing. That's why one of the things that we did was to try to approach the Constitutional Court in a direct access so that we can expedite the proceedings.
Yes. Thank you very much for that. Thank you. Thank you. Thank you. Mr. Moyo, Zonda Boniface Moyo. Is it accused number 2, Mr. Lepolo?
Yes.
Is he not feeling well? Mr. Lepolo, can we be of assistance to you?
Yes, can the court be of assistance?
What do you need?
Can I be provided with water, madam?
Of course. Of course.
But I hope he's
His legal representative, Mr. Reinecke, do you want to get an instruction from him? Thank you. I just want to know if he is well and able to proceed with the proceedings. Thank you. The court adjourns for a few minutes. If necessary, let us.
It seems he's starting to breathe. I ask that you just take a short adjournment.
If necessary, then get the necessary emergency services.
All rise.
Thank you. We'll adjourn for a few minutes.
Medical condition.
would you have any objection if the proceedings continue in his absence? I do not foresee any prejudice.
Neither do I, my lady. We can continue.
Thank you. So we can proceed.
Thank you.
Thank you.
As the court, please, my lady.
Thank you, sir.
Apologies for interruption.
No, not at all.
I had made a request in the morning, considering the fact that accused number 7 is sitting at the back and it's very far. So sometimes we want to pass instruction. So I had approached the prosecutor asking that he be brought closer so that there will be easy facilitation in passing of instruction. So I see one of the accused has been excused, so there is enough space if the court is amenable to just have him closer.
I would prefer that they sit in the sequence as they are sitting. He can just put his hand up, and if he needs to give you any instructions, I will allow you to go closer to him.
As the court pleases.
Good. That is also better for security.
As long as your ladyship can see his hand, because
I can see his hand, and I'll ask my registrar to also keep an eye on him, that if he raises his hand, that we will give him the necessary attention.
as the court pleases.
Thank you. Mr. Bester, you heard what we just said? If you want to give instructions to your counsel, you are welcome to just put up your hands, draw our attention, and we will ask your counsel to go to you to take instructions. Thank you. Thank you. Thank you. So we left off with accused number 8, Mr. Zanda Boniface Moyo. Mr. Moyo, thank you. Who is his legal representative? You, Ms. Kruger?
My lady, yes. During the adjournment, it was confirmed that Mr. Moyo will proceed with legal aid, my lady. So Mr. Mutlang already withdrew, so legal aid is officially, if I could put it like that, on record then for Mr. Moyo. Thank you,
And
my
if
lady.
you say legal aid is officially on record, is it going to be you that represent them, or is somebody else going to be appointed?
My lady, at this stage, it's not going to be me. He is linked to one of the practitioners that we already appointed, my lady.
Good. So that has been resolved. There's no necessity for adjudicare or other processes that has to be followed. That may
Not
be
with
good.
regards to Mr. Moyo, no.
Thank you. Mr. Moyo, are you then so satisfied that Legal Aid South Africa will represent you?
Okay, ukolile data ukuthi uvumelwa kumele bobela ukuthi kanye njengoba bavumelise sakho bavumelwa ngole kumele bobela ukuthi kanye.
Thank you for that, Mr. Moyo. Of course, also, just as I indicated to the previous accused, you must make sure that you stay in contact with your legal representative. It's your responsibility to ensure that your legal representative is properly instructed and that you are available for consultations at all times. You understand that? Ms. Kruger indicated to me that it might not be necessary herself that's going to conduct your case or represent you. So you must make sure that you find out who your legal representative is, how you can contact that legal representative, and how you must go about arranging the consultations or be present in the consultations.
So,
Thank you, Mr. Moyo. Thank you. This brings us to accused number 9, Mr. Joel Lechare Macheta. Thank you.
May I please the court, my lady, confirm my appearance on behalf of Mr. Macheta, my lady.
Thank you. Thank you, Mr. Macheta. Are you satisfied with the fact that your counsel will be appointed from Legal Aid South Africa? Thank you, thank you. You also heard what I said to the previous accused. It's your responsibility to make contact with your legal representative and to ensure that you are available for consultations and that your legal representative is properly instructed. Thank you, Mr. Moketa. Thank you. Now that we have resolved the issues of legal representation, you would have noted that I called this case management hearing due to some issues that has not been resolved during the appearance on the 13th of January 2025. I refer to paragraph 4.1 of the notice that I sent out, and that is the issue in regard to paragraph 2 of the order dated 13 January 2025. And that is the issue of the 7th accused to file his reply in terms of section 212B before the 28th of February. Mr. Mohela, that issue is also pending, am I right?
That is correct.
It is before my brother Dafio.
Not pending before your brother Judge Thabo, my lady. He has already determined the leave to appeal.
Yes.
But what is pending is the further appeals. But the accused is unable to exercise such a right because on the 13th of Jan 2025 there was an order, and we asked for reasons thereof, and then we filed an application for leave to appeal against that order, specifically the completion of 212B. And we're under the impression that on the day of the hearing, on the 13th of Jan, the judgment was given extempore, the reasons thereof for that particular order. So when the leave to appeal was had, we had transcribed the record of the proceedings, and we asked that the signature of the court be appended and it be a court judgment or the reasons of the order. But on the day of the hearing of the leave to appeal, that had not been done in terms of the signing of the reasons for judgment. So the first thing that we impressed upon the court is that we were of the view that the matter is premature, in a sense, or it's not ripe for hearing in the absence of the reasons being signed by the court. And then we were assured that it will be done thereafter, the hearing itself. Then we proceeded on that string. Then the leave to appeal was then dismissed. So we then asked that in light of the fact that we have the leave to appeal judgment, we sought also the judgment for the order granted on the 13th of Jan, and we had not received. In fact, what we received is that that order was given without reasons. So, and we were advised that if we are not satisfied with that, we can take it to the JP. So, my instructing attorney had drafted the draft letter to be addressed to the JP, and my instruction is that it's going to be sent immediately after this court for us to seek reasons, and so that we can exercise the further right that the accused might have, if so given such an instruction. But that matter, I just wanted to address that it's not pending before Judge Thabo, in the sense that he has already pronounced on the application for leave to appeal. But the short answer is that that statement itself has not been completed because of that process.
I saw a judgment of my brother Dafio on the 2112 issue.
That's a leave to appeal.
Is that the leave to appeal judgment?
Yes, that's a reason for leave to appeal. I think it's uploaded on Safli.
Yes, I saw that. So your gripe is with the fact that you didn't receive reasons on the judgment a quo, on the original judgment.
Yes.
So you cannot now take the matter further to the SCA.
Yeah, that's an impediment, yes.
Yes. So this is another pending matter that may cause us not to start on the 21st of January?
Not really. That aspect, my lady, it cannot stop the trial from starting. Remember, if everything is resolved in our favor in respect of Section 35, or if your lady can grant an interim arrangement for consultation, that issue can be resolved, the 212B statement, because the 212B statement, it's blocked by the pending application itself. Because once we consult fully, then we are able to participate meaningfully. Because we say that this is not a tick box exercise. We need to take instructions so that we can address certain questions that are posed in that questionnaire.
So if the consultation issue has been resolved, you will be able to take proper instructions from your client to compile a reply to the 212 notice and then supply it to the state and the court.
Yes, that is
it.
our condition.
Yes. So there is not pending litigation on that.
So there are two answers.
That's what worries me.
It won't the pending application. If by tomorrow we have all the consultation regime, the trial can proceed despite the pending application in 212B, because the pending 212B statement, it is in terms of the leave to appeal, we are saying that it has set a dangerous precedent. That issue can be sorted absent the continuation of the trial. The trial can continue simultaneously with that application. Unlike Section 35, Section 35 needs to be resolved for the trial to proceed according to how we view it. But Section 212B can proceed the further appeals, but it won't stop the trial as long as there's been consultation and we are ready for the trial.
I'm concerned about that because non-compliance with Section 212B might cause some calamity in the trial. But let me hear from Ms. Bester on your submissions to the court, because then the plea proceedings and what happens afterwards might be affected, and that might cause the trial to be suspended at that stage. Or yes, but let me hear from Ms. Bester what she says on that.
Oh, if there's something, I will have an opportunity.
You will reply. Thank you. You will have the last say. Thank you, Ms. Bester.
I see the application and what you want to do is quite simple. If they're able to proper consultation, they were able to submit their P1. So it's my submission.
If they want to.
If they want to. But remember,
I know. Yes.
So in fact, it's the admissions.
Yes.
And if they don't reply on that, whether they're going to not to reply on that, that's another issue. But I think this so-called pending application regarding the 212B is really a fruitless exercise. And everything is going to be finalised, quickly finalised, as soon as the decision is made regarding the application that was used for
Mbele. Thank you. Thank you. Thank you. Anything to add, sir? She actually agrees with you.
Yes.
Thank you. Thank you. Then paragraph 3 of the order dated 13 January 2025. All the accused persons' legal representatives shall ensure that they, by appointment with Senior State Advocate Bester on or before 31 January 2025, download the information held by the state in digital form by making use of their own memory sticks or similar devices. Has this been resolved by everybody, Mr. Motlaung?
As a court, please, my lady, to a large extent this was complied with, except that at some point I was in contact with my learned friend from the state with regards to us just ensuring that we are in sync, that what they have is what we also have. So there is that process that is underway, which would not be an impediment in us proceeding further.
As long as you give me that undertaking, that it will not cause any delay in the trial?
Indeed,
Thank
my
you.
lady.
Thank you. From your side, Mr. Reyneke?
I've served in my notice, my reply that I've received, and my things are all up to date that I've got from Ms. Wester.
Thank you, Ms. Kruger.
Confirm so, my lady, thank you.
Thank you, Mr. Mohela. Did you receive?
The answer obviously flows from accused, Mr. Muto. We had made arrangement because he's improved from him that when he goes there with the USB, he also is sourcing that information for accused number 7. And all these arrangements are in line with the current status.
Good. But you, in the end, the buck stops with you.
Yes.
You must make sure
Yes.
that you have all the information.
Yes.
You can't later come and say Mr. Mutong made a mistake. He didn't get all the information and blame him for that.
No, we can't blame that. It's just like a messenger, but we can't blame him for that.
We won't kill the messenger, Mr. Mutlang.
I'm so relieved.
We will not kill the messenger.
I'm relieved, my lady.
Yes. Thank you. Thank you. Thank you. Then paragraph 4 of the order. All the accused persons, legal representatives, shall on or before the 31st of January 2025 and at their own costs obtain hard copies of the extra statements obtained by Advocate Bester. Mr. Mutlong?
That's the same process.
Same.
As a process.
Is it still in process or has that been completed?
It's in process in terms of us having to ensure that what the state has is exactly the same as what we have. So it's more of us having to reconcile what we have. But we have the necessary docket from the state, and what we have, my lady, I must just take the confidence that what we have is enough to ensure that we are ready and for trial.
Thank you for that undertaking. It's indeed helpful. Thank you, Mr.
I
Reyneke.
can confirm it as such, Mary.
Ms. Kruger?
Confirm, my lady.
Thank you.
Accused number 7, same arrangement as order 3.
Thank you. Thank you, Mr. Moena.
The last part of this statement, I didn't give it to Mr. Mutong, so they don't have it. So when I spoke to the container, I didn't put it to them. And I didn't receive any request. I provided them with an amount on the 14th of January. And I didn't receive it. In fact, I didn't think Mr. Mutong's job at all. You got it, I don't know from me. But if there's something missing, I'm not responsible for that.
But he indicated that he is going to consult with you and to just, as he say, reconcile the documents and make sure that he has everything. So I've got an undertaking from him. Thank you. Thank you. Then in regard to paragraph 5, that is the issue of Mr. Sekeleni's legal representatives. I can just emphasize here that the order, Mr. Sekeleni, was that it is recorded that the fourth accused, Mr. Sekeleni's legal representative, has withdrawn and that Legal Aid South Africa has been approached for legal aid. But as indicated by Ms. Kruger, who appeared on his behalf, the application for legal aid has been dismissed, but that she will assist accused 4 in his appeal procedure forthwith. She did assist you. You did not come to the table. Ensure that you keep in contact with Ms. Kruger and that you supply her with the necessary information and documents so that the appeal can be finalized on this issue.
So the proving and Sudanabo, there are not create, you create a sort of say,
Thank you very much, Mr. Sekeleni.
We are creating now.
Okay, let me introduce you formally so that there is no... Ms. Kruger, can you just stand up? This is Ms. Kruger. Before you go away today, Mr. Sekeleni, make sure that you have her contact details.
My lady, I can confirm I have been in contact with Mr. Sekeleni. I have his telephone number, I have his son's telephone number, I have his email address, and we've also arranged that he must come to the office now after the court appearance, my lady.
Thank
so you will be coming to the office. Thank you, my
Mr. Sekeleni, just again to emphasize, if you do not participate, if you do not do your due diligence to obtain legal representation, the court may, in terms of section 342A, in the interest of the administration of justice, order that the matter proceed with or without a legal representative for you. So be very careful that you attend to Mrs. Krug or Ms. Kruger's office. Any questions from your side, Mr. Sekeleni? Nothing. Thank you. Thank you. Then, thank you, Mr. Best. Who's accused number 8? Accused number 8, whose client is that?
That's legal. Sorry, my lady, that's legal aid.
He's raising his hand. Maybe you can just get instructions from him quickly, Ms. Kruger. You may approach.
Thank you, my lady.
Thank you.
Thank you, my lady. It's just with regards to consultation. Thank you, my lady.
Thank you. Thank you. It's good that that seat has been planted now. Thank you.
Thank you, my lady.
Thank you. Then the last issue, and I think that is also a crucial issue, Mr. Mtlong, it goes to your client. Any outstanding litigation or issue that might affect commencement of the trial on 21 July 2025. There is the extradition judgment in the SCA.
Indeed, my lady, it's actually no longer in the SCA. Judgment was issued, it was delivered, and the matter is now before Constitutional Court. We have referred the matter in terms of 19 of the Constitutional Court rules for leave to appeal the majority judgment which was delivered in the SCA. So indeed, this is a pending matter.
And what effect will that have on the case itself? It goes to extradition and jurisdiction.
It goes to jurisdiction, my lady.
Yes.
It directly has an impact on the matter, inevitably.
Yes, yes.
Indeed.
So, on that issue only, do you foresee that the matter will be able to proceed? We will be able to proceed with the matter on the 21st of July?
Well, it's unlikely. It's unlikely because the issues that will be raised on the 21st, it's issues that are before the Constitutional Court.
Yes.
So that in itself would impede on the matter or impact on the matter proceeding on the 21st of July.
Yes. So it will go to section 106 of the Criminal Procedure Act and the jurisdiction issue.
Indeed, my lady.
And if that is resolved in the Constitutional Court, then the matter can proceed.
Indeed, my lady.
Without any impediment. Thank you for that, Mr. Mthoni. Thank you. Then, Ms. Bester, you had some issues that you filed with your counterparts. If we can address those, I think we have addressed some of them. Oh, that's good.
Just the financial aspect, there are financial instructions made. Did you see the matter?
Yes, I think the accused that has legal representation on private mandate, Mr. Motlaung, Mr. Mohela, you are satisfied that you will be able to see this matter through until the end.
Indeed, my lady.
Thank you. That's your undertaking and commitment. Same for you, Mr. Mohela?
Yeah, that is true, my lady, but with a caveat. With just a caveat. In that I know that the trial has been estimated to run for 6 months on estimation, but depending on the consultation itself, we can fully confirm. But for now, we've been assured but not placed.
In funds?
Yes, for the trial itself. What we've been, it's been ad hoc invoicing from now, but for the trial itself, it will be dependent on the fullness of the consultation.
We can't continue on that premises. You will have to give the court an undertaking that you will see the trial out until the end. Remember, there is case law. The debt that happens between you and your client is between you and your client. It's nothing to do with the court. You must take the instruction or not take the instruction.
May I please approach my lady?
Yes.
Thank you, my lady. I just wanted to clear that particular aspect, and then I'm indebted to your lady for asking me to clarify it. I can confirm that I will see the trial through.
Thank you very much for that. That's a huge undertaking. Thank you. Thank you very much for that commitment, Mr. Mahela.
My lady, if there's nothing that, because I was just waiting for everything to be addressed so that I can make one request, but I'm in the court's hand. If everything is sorted, then to be given an opportunity.
Good. So I think we've dealt with all the issues. As soon as Advocate Bester and Advocate Motlaung is done with their consultations, we can proceed. I know it's necessary to consult, very necessary. So I think, Ms. Bester, anything else from your side?
That was what's all the consultation about, and that was the 212 visa accused number 8. And I don't have a copy of that. I went through the court file with the help of the secretary. We can't find the copy of that. Mr. Martin showed me now on his tablet that it is indeed written. So now I don't know. If he did it twice, then it's still fine. Because he's no longer representing me. So,
Accused number 8. So you will have to consult with the legal representative of accused number 8. So I'm sure that between them they will resolve the issue.
and maybe we can see the time with
Good, good. I'll get to that just now. I'm sure that's easy to resolve, Mr. Mutlong.
Indeed,
Ms.
my lady.
Kruger?
Indeed so, my lady, yes.
Thank you. Thank you. Accused 3, sir, your hand is up. Who is his legal representative?
May I just approach accused number 3?
Thank you.
Thank you, my lady.
Thank you. Thank you, Mr. Reineke.
Thank you for the indulgence, my lady. Lady, Ms. Bester and I had a short and sweet discussion. Accused number 3 has moved house. He used to sign as part of his bail conditions at Kagisanong police station. By agreement between the parties, I'll ask the court to amend the order that he signs at exactly the same dates and times per week as he has to sign, but just at the Mangaung police station and no longer at Kagisanong.
Thank you.
Thank you.
You can regard the order as being so amended,
Thank you.
but I will do a formal order on,
Thank you, my lady.
on that. Thank you. So where was I? Ms. Bester, you indicated you have nothing further.
I don't know what to say any further, my lady, because it appears that we're not going to proceed on the 21st.
Absolutely, and it's a blessing that we did this inquiry or this hearing today. This might not be the last one before we start in the end. I'm going to keep doing case management on this matter.
If I may have a suggestion. We set the matter down for the last week, the ending, I think last week, November, first week in December.
Yes.
And then the whole first in 2026. That we will keep
2026.
that 2026. But we will keep that and maybe have again postpone this matter to a provisional time to see what is going to happen in the constitutional matter as well as the application with accused number 7. Just regarding the constitutional matter, the interpretation aspect when they first the constitutional talks about interpretation. That is our case. And the respondent is going to file the news today. So if they grant permission, it's going to take a longer process. If not, we can finalize.
Good, good. But I will keep on doing case management on this case. Mr. McLung, nothing to add?
Nothing.
Thank you. Mr. Reineke?
Nothing new, thank you, my lady.
Ms. Kruger?
Nothing, thank you, my lady.
Thank you. You wanted to address the court, sir?
As the court please, my lady, it's not nothing to add, but it's just a request two requests because the accused is before your ladyship. The first one is simply to ask for an interim measure if your ladyship is amenable for consultation so that we can be somewhere when we come back for the second case management.
I can't do that, sir. That is, first of all, I'm of the view that it is part of the executive's, it's the executive's priority. It lies within the realm of the executive. Secondly, you have this litigation pending. So I'm not going to make an order in contradiction to the litigation that's pending at the moment. I cannot do that.
I won't take this matter further, my lady. I just wanted it.
Thank you.
But if
You've made the application,
yes.
you've served
It's
your
pending.
client. Thank you.
Yes.
Thank you for
The second
that.
aspect, my lady, we normally take this opportunity after court to consult with the accused. That is the request that we are making for today.
Again,
Yes.
completely outside of my realm. I cannot order the correctional services people as to how they conduct their processes. So I'm not going to make that order. There is the issue of security. There's a lot of factors to take into account. So I am not going to make an order in that regard.
As the court is made.
Thank you. You can always go and consult at the prison if necessary.
As the court
And I do not know if we really have the facilities here to accommodate that.
We do, my lady, because I don't want to speak post the pronunciation, my lady, because obviously that's incompetent. But mostly the accused is brought to court in the morning until the end of the court day. So they take advantage that he's leaving at 11, but it's not the executive arrangement. It's just how the proceedings would have unfolded. So normally we would say that it's actually an issue of courtesy, that can we just see him for 2 hours, and not because of executive arrangement. He was in court, he was going to, if we were going to argue for the entire day, we will be released probably at 4. So that means the court can still keep him until 4 because it's before the court. But I don't know.
I'm not keeping him until 4. That will be very, I'm not keeping him until 4. But of course you can build relations with the personnel of the Department of Correctional Services, and they can assist you. Mr. Do you have something to add on that?
Yes, my lady. One of the colonels of the correctional services are in court, and we had a discussion, and he will do it. He will do it, but he will only allow 1 hour.
Good. So there you've built the relationship. So please continue to do that and see what can be done. Thank you for that request. Then it cannot be. Good. Then that leaves us with the accused. I just want to quickly confirm with the accused whether they are all satisfied or whether they have anything to add. Accused number 1, Ms. Mkudumani, you're satisfied? Thank you. Accused number 2 is not here. Accused number 3, sir? You're satisfied. 4, Mr. Sekeleni? Thank you. Accused number 5, Mr. Masukela?
Charges were
He was withdrawn. Accused number 6, Theo Franz Mahotsa, sir? Thank you. Accused number 7, Mr. Bester?
Your Honor, I just want to state that my instructions to my legal teams to try and process this consultation issues or whatever issues will be to prepare the trial as soon as possible. Because I do also feel that the trial is effectively the analyst. So I would like to seriously report that my full commitment to try and finish this trial as soon as possible.
I so appreciate that insight and that commitment, Mr. Bester, because it's in the interest of the administration of justice and everybody present that we expedite the matter. Thank you for that commitment. It is appreciated. Thank you. Accused number 8, Mr. Moyo.
No, I'm satisfied.
Mr. Mageta, last but not least, satisfied, thank you. So what I would want from you is to draft me an order as to the postponements, the arrangements you want for us to make in the order, the filing of the 2112B statements, everything that you want to be in an order, draft it for me, and then just submit it to me in chambers. I will just go through it, and then I will make the draft order then an order of court if it is in order.
Already set the date.
Yes, the date is then the date that was in the order of the 13th of January, and that was the date of, let me just see where it is. Can you remember? It is the 10th of November until 5 December. It's in the order of the 13th of January, and as well as the first term of 2026.
My proposal is, can we postpone this matter still to the 21st?
For?
Further case management. Because then hopefully the appeal procedure will be sorted out, and then we would know if there is indication. Most definitely like constitutional or maybe not going to be in time. And hopefully regarding the
That's not going to
the
happen.
last one is not going to
Yes, that's not going to fly, but a good try, Ms. Bester. Very positive. So maybe between all the council, they can decide on the next case management hearing a date, so that we don't have to have emails to and fro, and you have your diaries, decide on it now and then include it in the draft order for us, and then I can also know how to arrange my diary for the court terms that are to follow. So just now, am I going to make that order in court, or will it be a draft order made in chambers? I prefer in court. How long will it take you? Good. It is now 11:31. Shall we reconvene at 12?
It's an order, lady.
Thank you. The court then adjourns until 12. Thank you.
Nee, die weet kantoor maak hom gou gaan haal. Yes, die regter is nog hier.
you. Thank you. I want to thank Council for the draft order. Just the first paragraph, the position in regard of the accused. If my memory serves me right, accused number 1 is in custody, bail was refused. Is that correct, Mr.
That's correct, my lady.
Accused 2, we have now arranged that a warrant of arrest be issued, but to be stayed over until 19 September.
That's a good position, lady.
Thank you. Accused number 3, his position on bail. Which accused is it? Oh, and that is his bail conditions that are to be changed to a certain extent. Thank you. Accused number 4. Withdrawn. 7 in custody. 8. Mr. Moyo in custody. Bail refused. And then
His 9 is on that.
on that. Thank you. Thank you. And then I note that the 19th of September is that for the next case management hearing.
It's the last day of the term.
Thank you. The accused may then rise. Thank you. First of all, the matter is then postponed to the 19th of September 2025, again here at the High Court in Bloemfontein at 9:30 in the morning, and that is for a case management hearing. As indicated, the case will proceed or commence at 9:30 in the morning. It will be in this same court again, Court A. B. Where are we? Court A, Court B. Court B. It will be in Court B again. Good. Then in regard to accused number 2, a warrant of arrest is authorized against him, but the issue thereof is stayed over until the 19th of September 2025. Secondly, the trial dates, as agreed before, also remain the same. Let me just return to the accused. Accused number 3 is on bail. His bail is extended, except for the conditions as to the change of the venue where he must report, and on every Monday between the hours of 6 and 1800 hours. Accused 4 is also on bail. His bail is extended on the same conditions, and he's also warned for 9:30 on the morning of the 19th of September. Accused 6, similarly so, he is on bail, bail is extended, and on the same conditions, and he is also warned for 9:30 on the 19th of September 2025. Accused 8 is in custody. Accused 9 is also on bail, bail extended, on the same conditions as were fixed before, and he is also warned for 9:30 on the 19th of September 2025. So very important, I will see all of you again on the 19th of September 2025 in the same court at 9:30. Should the accused that are on bail not attend court at 9:30 on the 19th of September 2025, a warrant of arrest may be issued. They may also forfeit their bail, and it may be that they will be ordered to remain in custody until the end of the trial. As I indicated, the trial dates for the 10th of November until the 5th of December and the 19th of January 2026 to the 29th of March 2026 still remain. The outcome of accused 4's appeal at Legal Aid South Africa against the refusal of legal aid will be communicated on or before the 21st of July 2025 to accused 4, the court, the state, as well as all the other parties in this matter. The reply in terms of Section 212(b)(3) of the Criminal Procedure Act, Act 51 of 1977, on behalf of accused number 8, will be served and filed at court and on the state on or before the 27th of June 2025. I will add here that it also be served on the other accused.
As please the court.
I already dealt with the bail conditions of accused number 3 as well as the warrant of arrest for accused number 2.
Number 3 to say
If there is not anything else, I then adjourn the court for the day. Thank you very much.